Okay, welcome. Welcome, everybody. Welcome to the weekly appointment here at the School of International Studies with our guest lecture series. Today is a real pleasure to have here Dr. Lorenzo Cottola. Dr. Cottola is Principal Research and Head of Law, Economies and Justice Program at the International Institute of Environment and Development in Edinburgh. He joined the Institute in 2002, and previously he was working for the Food and Agriculture Organization of the United Nations. Dr. Cottola holds a PhD in law from the University of Edinburgh, and he has expertise in a wide variety of fields, including international economic law, trade agreements, investment agreements, human rights law, the law applicable to transnational value chains, which he will illustrate as well today, as well as political economy of natural resources. Today, Dr. Cottola will discuss with us regulation of critical minerals in international treaties. His presentation is taken from an article that appeared in the Trade Law and Development Journal, titled Critical Minerals, International Economic Law in Global Resource Rush. So let's welcome Dr. Cottola with a round of applause, and then I leave the floor to Lorenzo for his guest lecture.
Thank you very much, Sondra, and thank you very much to the School of International Studies and to GreenDeal-NET for the very kind invitation. Thank you all for being here today in person and online. I'm very absolutely delighted to have this conversation together about the regulation of critical minerals in international economic treaties. And I would like to highlight a few issues as a broad field, but highlight a few issues together. And in doing that, I would like to ask a few questions about a just energy transition, which is really the buzzword in many ways that we see in many international policy fora. Just by way of additional background on the work I do. I work for IIED, it's a policy research institute. So the work we do, the research we do is very much action-oriented, is policy-oriented. As IIED, we work to promote a fair and sustainable world. And I myself am part of a team called Law, Economies and Justice, and we work on renegotiating the law to promote fair and sustainable economies. So the work we do is very applied in that way and ranges from supporting people who are impacted by large-scale projects around issues such as land rights and water and so on, all the way to engaging with the global talks where reforms are discussed around international frameworks, governing trade and investment and so on. Today, however, I like to focus on a paper that Sondra mentioned that is looking specifically at trends that are emerging in international economic law with regards to so-called critical minerals. And I would like to cover three main areas. One is to provide a brief overview of the global political economy concerning the rush for access to critical minerals. I would like to explore in particular the role of law and specifically international and economic law in that process. And then I'd like to conclude with a few thoughts specifically on the sustainable development provisions and the place of rights in those provisions. So to start with, I'd like to say a few words about the concept of critical minerals, which we see in many instruments, many legal and policy instruments, and a question about sort of critical for whom and to be fulfilled by whom, right? Sort of who is it that is looking at these minerals as critical? And very often we find this language, this framing in policy instruments that originate from primarily consumer countries, from consumer countries that are concerned about security of supply of certain raw materials such as lithium, cobalt, copper, nickel, etc., with the issue of criticality being not so much a function of inherent property of those minerals, but rather of an assessment of the importance of those minerals and of risks that affect the supply chains through which those minerals are accessed, okay? And so it's that sort of framing and perspective, and we see that actually different countries or different polities have reached different conclusions on the assessment of which minerals are critical, right? So there's some commonalities, but also some differences in the official lists that different different countries have put together, whether the EU, the US, China, and others. But what we're seeing across the board is a very strong interest on the part of large economies in securing access to these minerals. And we see a number of reports in the media and elsewhere that really talk about a rush for lithium, a rush for some of these other minerals. And sustaining that is a projected increase in the demand for these minerals driven by the shift towards lower carbon energy sources, in particular electric vehicles, EV, increasing demand for minerals such as lithium, for example, and other minerals. So strong connection with the energy transition, but not only. Many of these minerals are also important in sectors such as IT, aerospace, defense, etc., etc. So critical with regards to the energy transition, but also a wider set of economic sectors. And an additional factor that is worth bearing in mind is that not only is demand increasing and projected to increase, but also there are some features of the supply chains linked to these minerals that have raised particular concerns among certain consumer countries. If we look, for example, at resource extraction, the mining of some of these minerals, they are often heavily concentrated in a small number of countries. If you take lithium, a large share of the lithium supply at extraction stage come from a couple of countries, Chile and Australia. If you look at the cobalt, a substantial share of cobalt comes from the Democratic Republic of the Congo in terms of mining. Nickel, we can say the same about Indonesia. Graphite, predominantly from China, et cetera, right? So concentration in the resource extraction stage. But also very importantly, if we look at the whole supply chain, we see that there is strong geographic concentration in other segments of the supply chain as well, and in particular, the processing stage. So if we look at processing, we see that China plays a key role in the processing of a lot of these minerals, okay? So play a key role in supplying a large share of these minerals. And that's the result of sustained investment in processing capabilities in China over the years with various forms of state supports that have enabled China to acquire that preeminence really in the processing of many of these critical minerals. Now, I think we're all broadly familiar with the overall landscape, the shifting geopolitics that we're observing at the global level, the rivalries, the strategic rivalries that are becoming more and more intense between the US and China, the place of the EU, et cetera, et cetera. And so there's been concern that the sort of projected demand for the minerals in situations where there are essentially, there's this sort of geographic concentration in terms of where the produce based on these minerals is coming from, is creating risk for the supplies of countries such as the US or the UK, or here in Europe, the European Union. And so a number of these countries and polities have adopted legislation and policies that are essentially aimed at reducing dependence on a single large or a small number of large suppliers of these minerals, both by promoting domestic industry and also by diversifying supplies through partnerships with producer countries. Okay, so there is that sort of drive in many sort of so-called consumer countries. Now, I've been emphasizing so far the picture as it appears from countries that are essentially large economies and are looking for supplies of raw materials. What does the picture look like from the point of view of countries that have significant mineral wealth? Okay, and so we're seeing a number of policy developments in those countries as well, partly in order to facilitate the extraction of these minerals. Okay, but very importantly also aimed at promoting value addition in those countries. So countries such as Indonesia, Chile, a number of these countries that have significant reserves of these minerals are saying, we don't want to just export raw materials. We want to export processed, at least some level of processed goods, okay, based on those minerals. And here the screenshot is in fact from the ceremony, from the launch ceremony of a project, an ambitious project of the governments of the Democratic Republic of Congo and Zambia. They are looking to develop a supply chain for EV batteries based on the minerals that they have on both sides of the border. And so there are plans for setting up special economic zones on the two sides of the border and sort of varying degrees of sort of processing activities there. All right, so policy initiatives in that way, and also some of these policy initiatives in producer countries also have trade aspects. Okay, so there is an inventory, a database that the OECD is keeping of sort of measures concerning trade that are more essentially trade restrictive, and you can see that over the years there has been an increase in the number of trade restrictions, with countries saying we don't want to export raw materials, so there are trade bans or restrictions on the export of raw materials, and instead they want to promote export of processed goods. One example is Indonesia, one that is often mentioned as an example. They introduced a ban on the export of unprocessed nickel ore, and they're saying from now on we really want to process the nickel here. And actually that policy has been, from that point of view, successful in the sense that Indonesia now has a domestic processing industry, even though there has been a WTO case and a WTO panel that has found that those measures were in fact in violation of the WTO rules. Okay, so quite a bit of activity in terms of policy in both consumer countries and producer countries. And I also should say that I'm using these labels of producer and consumer as shorthand. Of course, you have many situations where a country is both producing and consuming the minerals, okay, or aspiring to. A few more elements of context here. Of course, mining is an industry that has been traditionally associated with a number of problems around social and environmental issues. And in the industry, people talk of ESG, E, environmental, S, social, and G, governance, ESG issues. And recent surveys in the industry show that, at least in segments of the industry, there's greater awareness of these issues. There's greater experience with supporting community projects, for example, that are meant to benefit people living around the mining sites, et cetera, But if you look at social developments connected with the rush for critical minerals, you also see a number of ESG issues that come up all the time, whether it is artisanal miners that are squeezed in unfair relations in their value chain, for example, cobalt miners in the DRC, whether it's indigenous peoples that are claiming land that is now being allocated for large-scale mining projects, and estimates suggest that a very large share of critical minerals projects, either ongoing or in the pipeline, are located on lands where indigenous peoples are present, and or other groups that have a strong connection to that land, right? So you see a number of aspects here that outline what is, I think, a multifaceted problematic, right? Where you the issues range from accessing the minerals through investment and trade, investment in mining projects, trade in terms of moving the minerals from one country to the other, all the way to plans for industrialization in the minerals-rich countries, or issues around the respect for the rights of indigenous peoples whose lands are being impacted by the project. So a very wide range of different issues that are really engaged by this rush for critical minerals. We are seeing what could be termed a policy rush as well as a resource rush. We're seeing not only is there interest in the minerals, but also there's been a flurry of policy announcements that are aimed at pursuing specific aims, right? Objectives, whether it's securing access to the minerals, whether it's harnessing the minerals for value addition and other economic activities. And in that context, I'm particularly interested in this sort of use of policy levers. I'm particularly interested in the use of legal instruments, of legal levers. And here I'm thinking about existing legal infrastructure that is extremely important. Of course, the WTO treaties, concerning, for example, trade in goods, will be very relevant to the trade in energy and raw materials, goods, and so on. The bilateral and regional free trade agreement, the bilateral investment treaties. These are networks of arrangements that exist and are highly relevant here, but I'm particularly interested in new instruments that are now being developed, partly in response to perceived gaps in existing legal frameworks, okay? And these new instruments, there's many of them, and they typically involve an encounter between different policy objectives, accessing the minerals, promoting value addition, for example. And they also come in many different shapes and forms, okay? So they may have different actors. Some of the agreements are being negotiated between an importer country or a consumer country and a producer country, right? Whereas others involve collaboration between two importer countries. So those agreements agreements will be quite different in that respect. They can vary a lot in terms of the scope or the focus of the agreement, right? Either solely focused on critical minerals or looking at critical minerals in a much wider, more comprehensive set of legal provisions. Legal nature can be binding treaties, or in fact, we'll see that there's also many instruments that are now being negotiated that are not treaties per se, they're not binding, they are looking at promoting change in some other way, okay? So what I like to do, just because there's so many of these instruments, is just to flag a few examples to illustrate different types. And then on that basis, we'll look at some of the provisions together, okay? So one example I like to flag is the free trade agreement between Chile and the EU. Chile, we saw that in the figures, is a major producer of lithium, yeah, major producer of lithium, so strong interest on the part of the EU and others for that resource, as well as for other reasons. The EU and Chile have had a free trade agreement for a long time, since 2002, but recently there's been a renegotiation or a negotiation to modernize that agreement, okay, that, as in many recent EU treaties, includes, in fact, two different aspects. One is the EU-only agreements that the EU can ratify at its own level because it falls within the exclusive competence of the EU, and then a wider set of issues that are part of a fuller agreement that requires ratification also by the member states, yeah, because it's a shared competence. And so it's a complex set of instruments, really, but we'll talk about it as being a free trade agreement. And what we see is that through this renegotiation, through this modernization process, a number of chapters have been added. And one of the chapters that has been added is the ERM, Energy and Raw Materials chapter. Okay, it's one of the first instances where the EU is actually having a full chapter devoted to that. The approach is now being explored also with other producer countries. But it's also important to recognize that while in terms of title, one chapter seems super relevant, particularly relevant, in fact, other chapters as well have a lot to say about trade and investment in relation to critical minerals. There's a chapter on trading goods. Critical minerals, of course, would be covered by that. There's chapters on investment. There's a chapter on trade and sustainable development. And just to illustrate how these things work, yeah, how this interconnectedness between the different chapters, if you take the aspects of trade, yeah, there's a chapter on trade in goods that covers aspects such as restrictions or prohibiting export duties, prohibiting export restrictions. Remember that from the EU perspective, from the perspective of the consumer countries, a key interest is in being able to access the resource, right? And we saw the rise of restrictive measures, so the trade restrictions. Yeah? So we see a number of provisions that go beyond the WTO rules in disciplining sort of the use of export restrictions. But if you look at the energy and raw material chapter, it goes beyond that. It says, okay, that all applies, trading goods, relevant here. But in addition to that, we also want to cover some indirect forms of export restrictions that could be particularly relevant to the sector. And so the ERM chapter, for example, prohibits the use of import or export monopolies. It regulates the use of dual differentiated prices, whereby a producer country charges higher prices on exports and lower prices for domestic processors. And we'll see, as we start looking at the detail of this, we'll see some of the big picture objectives that I was discussing earlier crystallizing into legal language. Take, for example, the issue I just mentioned, the differential pricing. It sounds incredibly technical, incredibly narrow, but it's so important. Why is it important? Because from the point of view of a producer country, if you want to support processors, industry in your country, what you could do is to say, I'll make these goods available at a lower price for domestic producers and domestic processors, and that way I can make it cheaper for them to process the goods to the producing country, right? And so what the relevant chapter of this agreement has to say is quite a lot about this particular issue, right? And you can see that there's a provision that says you cannot impose a higher price on exports. But then it says, oh, actually, Chile could do that if it's doing it specifically to promote value addition in country. But then it says, but actually, even if it wants to do that, it needs to comply with a number of conditions. And you look at the conditions, And these include a number of things, such as not adversely affecting the capacity of the European Union to source raw materials from Chile. So you can see that there are sort of the different objectives of securing access to the materials on the one hand, and promoting value addition in country, sort of get translated into fairly technical, perhaps fairly boring and fairly dry legal language that matters a lot in the way in which these issues are understood. And in practice, I, for one, would be looking to see how these provisions are implemented, to see what their actual, where the balance actually falls, right, in between, in mitigating or managing or reconciling those multiple and to some extent competing objectives. So that's one example I mentioned, sort of the EU Chile Free Trade Agreement is a comprehensive agreement, a binding treaty, which includes provisions on critical minerals, and that is concluded between an importing country or sort of a consumer, a large economy that is primarily a consumer of these minerals, and a producer country. Now, the next example here is a different type of agreement, is an agreement between the US and Japan. So primarily two importing countries in that sense, right? Two major sort of economies looking at sourcing critical minerals. It's a treaty, so it's a binding agreement, but it's solely focused on critical minerals. It's a critical mineral agreement. And I'm not going to discuss the provisions quite in so much detail just now, but what I like to flag is that what we see if we look at these agreements is that while being a binding treaty, it primarily restates existing obligations. So if you look at some of the examples here, the parties reaffirm their obligations as they already apply under the GATT. The GATT is the General Agreements on Tariff and Trade, which is one of the key pillars of the WTO, of course, right? So these things already apply, already binding, but the parties reaffirm those obligations. There are some novel aspects. For example, a provision that says that the parties shall maintain their current practice not to impose export duties, right? So they're already doing it, but let's make it a legal obligation now. But by and large, is an agreement that restates existing things. And you sort of wonder why would they want to do that, right? They already have the GATT, you already have some of these obligations. Now, there's been quite a bit of commentary around this type of agreements in the literature and in public debates, but essentially one key factor, it seems here, is that the US adopted legislation called the Inflation Reduction Act back in 2022, that among many things, what it does is to create subsidies for EV vehicles and more generally for energy transition related activities. And the subsidies are connected to a certain percentage of the extraction or the processing of the minerals happening in the US or in any country with which the US has a trade agreement. Now, you think countries that are friends of the US in terms of geopolitics and foreign policy, et cetera, but do not have a trade agreement with the US currently say, hold on a minute, this is excluding me, right? So there's been a strong interest from countries such as Japan, but also the UK and others to say, we would like to have some form of agreement. And negotiating a comprehensive agreement is complex and time consuming, or maybe we can do something quite focused on critical minerals that allows us to meet this. And so you can see the linkages between what is essentially an international agreement and what is more like a national domestic legislation happening in a country that has got significant political and economic clout, of course, driving some of these dynamics, some of these developments in international treaty making. Now, I'm going a little bit fast, but just to give you a bit of an overview of some of the landscape here, I'd like to shift gears and talk about another example, another type of agreement that we're seeing that is quite different from the ones I've been talking about so far. The EU has been concluding a number of strategic partnerships with producer countries. Here you have examples from Kazakhstan, Chile, and Namibia, but there's several other agreements that have been put in place at this stage. So we have the importing country or the consumer country, the producer countries. Significantly, these agreements are explicitly not binding. They are not treaties, okay? These are agreements that do not create rights or obligations, that do not modify rights or obligations. Rather, what they do is to create a space for the parties to come together and explore ways to collaborate on developing, integrating the supply chains of critical minerals. Right? So it's a different logic compared to some of the treaties that we were looking at just now. And that logic is then reflected in the content of these agreements that are essentially about developing a roadmap for joint activities, and the issue of processing, which I mentioned earlier, the whole issue of value addition in country and the balance between different interests in relation to that comes up also in some of these MOUs, in some of these partnerships. So these are quite different because they're not treaties for lawyers. There's a very clear difference, right? From the point of view of policy, you're looking essentially at different tools for achieving or pursuing policy goals, right? One is the sort of signing of a binding treaty, and the other is creating mechanisms to talk more, to create linkages with businesses in our country and business in your country, to share information, to do that sort of thing. And the provisions in these sort of MOUs tend to have, it's not just about creating predictable rules or, non-discrimination and sort of transparency, but they're also about connecting businesses in that way, exploring joint ventures, exploring collaboration. So they're much more, in some ways, much more applied. Now, I'd like to come to some of the provisions on sustainable development in particular. And it's the final segment of the slides, as you might recall. And the reason why I like to flag this is that there has been, well, one is that at least in terms of policy rationales, at least in terms of the rhetoric, a lot of what we're seeing is driven by a concern about sustainability, right? The shift from fossil fuels to cleaner forms of energy. So there is that. But also, if you look at the content of these agreements, and we'll see that in a minute, sustainable development, issues of sustainability, issues of ESG, environmental, social, and governance, come up quite a lot. Yeah, they come up quite a lot. So this is from the EU-Chile FTA, free trade agreement, which has an entire chapter on trade and sustainable development in line with EU practice concerning free trade agreements these days that contain that chapter. The Japan-US agreement also includes extensive provisions on sustainable development themes, and so do the MOUs, the non-binding partnerships that the EU has set up with a number of producer countries. This is the same with Kazakhstan I mentioned earlier. If you look at another provision here, is the sort of reference to the application of principles of sustainable mining and processing, right? So part of that collaboration between companies across the two polities will be really about promoting more sustainable models, more sustainable approaches in mining. So there is that. I suppose one question then is, given that there is this sort of strong interest in reflecting sort of sustainability concerns in the agreements, what do we actually mean by sustainability concerns, right? How are these conceptualized? How are these understood? How are these operationalized, okay? And so when we start to look at some of the more detailed provisions of these agreements, some patterns emerge, okay? So this example, again, comes from the Chile-EU FTA, and we see that the first provision refers to sustainable development, policies and priorities. But if you look at the words that come up a lot in this and also other provisions in that chapter, it's really about two main issues, yeah? The environment and labor. And this is in line with EU practice concerning sustainable development chapters. If you look at what's in there, there's a strong emphasis on those two themes, but it's also in line with wider international practice that we're seeing also from the US. Again, if we look at the Japan-US critical minerals agreement, there's a detailed provision on the environment about ensuring compliance with environmental laws, et cetera, et cetera. I'm noting I was referring to the treaty having relatively few significant binding obligations despite enforceable obligations, despite being a binding treaty. If you look at the formulation, each party confirms its intention to do something, right? This is not the language of shall or creating an obligation. This is the language of saying we are already planning to do this, we're just putting it in writing, okay? So that's as an aside. So environment, and then also on labor, similar language, similar approach. So we see these two themes as emerging very strongly as the focus areas for the sort of sustainability dimensions of some of these instruments, okay? But if we look at the issues that are coming up in many of these projects, and this both is sort reflecting some of the dynamics in the lithium triangle. There's talk of a lithium triangle as being referring to lithium reserves in Argentina, Bolivia, and Chile. Yeah, so across those three countries, some of the issues that come up very strongly in that context are, for example, related to the rights of indigenous peoples over their land, the impacts that the mining operations will have on their land, issue of free, prior, and informed consent, so the application of norms under international law that sort of affirm the rights of indigenous peoples, including in the context of investment projects. And there is rich jurisprudence in relation to that under the Inter-American Court of Human Rights that has really clarified the implications of those rights, particularly of indigenous peoples, in the context of investment processes, as requiring, for example, certain forms of public participation through the notion of free, prior, and informed consent, but also other dimensions around benefit sharing, the negotiation of benefit sharing arrangements with those indigenous peoples, the conduct of impact assessment, et cetera, right? So there's if we look back at some of these economic agreements I was mentioning, there's less reference to these aspects, okay? So there is less direct reference to this aspect. The provision here comes from the Chile-EU free trade agreement, okay, which includes language that is broad enough to potentially capture some of these issues around, for example, responsible business conduct, corporate social responsibility, supporting the dissemination and use of relevant international instruments, which include the guiding principles on business and human rights, which are a key document with regards to the responsibility of business in the field of human rights. Okay, so these are very, very broad provisions, but there's nothing really. So we could say that actually this is relevant, you know, to a situation like the one I outlined concerning the rights of indigenous peoples, but there's nothing that is actually quite so explicit in the way that we saw in relation to labor or the environment. Okay, so there are questions about the articulation between the international system of protecting human rights, including in relation to indigenous peoples, and this sort of agreements that we're seeing that are not quite so explicit in relation to this. So where does that leave us? It's been, I guess, a broad overview of some of the issues, some of the trends, trying to connect the legal instruments to the wider context and why we're seeing those legal instruments formulated in that way, what issues they respond to. One broad sort of thought that I took away from doing this work is just highlighting the role of public policy, including in the form of legal instruments, including international legal instruments, in this sort of struggle to sort of access, control, not only the minerals, but also the supply chains around those minerals. And at the same time, you know, we're also seeing widespread use of instruments that are not legal instruments, let alone comprehensive trade agreements, okay? They're narrower in focus, or they are not even binding treaties, they're more flexible instruments. And to some extent, that is reflecting trends that are also happening in other sectors of related to international economic law, but it also reflects, in my mind, a time dimension, the need to act now, the need to act quite quickly in that regard versus the time that it takes to negotiate these sort of comprehensive agreements, let alone getting them ratified and coming into full effect. So we're seeing this sort of the limits also of the full-fledged conventional legal instruments through trade agreements, through the development of alternative arrangements. We're seeing different types of legal arrangements emerging that are quite different. They're quite different. So we're yet to see, in my mind, a coherent body of law, or maybe we'll never see a coherent body of law. What we're seeing is a patchwork of different instruments that will respond to different considerations and also different approaches, different policy approaches. The US essentially went ahead with its own domestic legislation that started driving then some of the international negotiations. The EU has been negotiating bilaterally, primarily, as well as developing its own legislation as well. I think there are a number of questions about the just energy transition here on multiple levels, and I've touched on some of them. I mean, this issue of how can mineral-rich countries promote value addition in their countries so that they're not just exporting raw materials. It's very, very important to many governments in those countries. Like, what are the instruments that can facilitate that while also allowing sort of consumer countries to feel secure in their access to the resources. So that's one area. We've seen the issue of rights. We talk about sustainable development, but what does that mean? We talk about ESG. What does that mean concretely? How does that translate to when it comes, for example, the articulation with human rights law, when it comes to the articulation with issues such as indigenous people's rights? Very generally, I think very broadly, and I'm particularly interested in thoughts from this audience in person and online on this. But in my mind here, there is a really fertile ground for interdisciplinary approaches, because I think, to make full sense of what these legal instruments say, we need to understand the complex geopolitics from which they emerge. Otherwise, an agreement like the one between Japan and the US doesn't really make sense, right? It doesn't really say a huge amount, but as you start looking at the wider picture where that agreement fits, you start seeing some of the logic of it. And so really exciting, I think, space for looking at the law in context, as part of its wider economic and political context. And I'll leave it at that, just flagging in the article that Sondra very kindly also highlighted. It, as it happens, it just came out a couple of days ago, so it's available online. And I've drawn some insights or highlights from it, but there's much more in it. So if you're interested, I'd be delighted if you could take a look. I'm looking forward to hearing from you, both your own thoughts and contributions. I'm sure you have plenty to say, as well as questions if there are any. Thank you so much.
Thank you, Lorenzo, and thank you also for persons attending online. I would like to add that this guest lecture is also part of the GreenDeal-NET series, the Jean Monnet Research Network, and so we have some persons following online that are welcome to ask questions as well. I would like to open the floor for questions from our, yes? Oh. Okay, so we open the floor for questions and welcome especially questions from our students. So please don't be shy. Yes.
Hello, I'm Valeria. I am finishing my PhD here at the School of International Studies, and I'm going to ask a very mean question to you, so I'm sorry in advance. I am working with the Chinese framework for critical materials and rare earths, and I was asked fairly many times whether the EU's approach to critical raw materials vis-a-vis China, because of our interdependence, is going to last right now as it is. Because in my experience, the legal framework that we have, at least in European Union vis-a-vis China, is not working very well, is not feasible. So my question is, again, very mean, and I'm sorry, but do you think that the principled approach that is now encompassed in many legal instruments, especially considering the EU ones, is going to work, or we are going to just have fancy laws that are little to not going to work with the overall policy?
So thank you very much. First of all, wonderful presentation, very inspiring. I have three short questions, super short questions. So the first one is, when you presented us the Japanese-US agreement, to a certain extent, I see your point. It doesn't make any sense to have a bilateral agreement which is restating the WTO commitment, unless you know that you're going to infringe the WTO, let's say, rules, and you want to make sure the partners that those are not going to be hit by your action. So I would like to understand whether these bilateral treatments are more political, let's say, have a political meaning. Secondly, you mentioned this idea of the chapters about sustainable development as being quite light, promotion, cooperation. On the other hand, they can be also associated with more active enforcement measures, no? Like the carbon adjustment mechanism. There, you don't ask whether you, let's say, satisfy the requirements, or you are either penalized in terms of tariff, or you are excluded access. And the third thing regards this article that come out very recently in the Journal of International Economic Law about level playing field, what it means. And I found it very interesting because the authors argue that in the past, the level playing field was important only within the EU, but not at the world level. In the sense, if you're a developing country and you want to pay little your workers, that's your comparative advantage. And so you can do it. Here, we have more and more of these S&D objectives. So it seems to me that you may end up with a world where you have developing countries that want to adopt these more advanced forms of protection for the environment, labor laws, and so on and so forth. And they may sign this agreement. Then the others then instead prefer the Chinese way. Don't ask, don't tell. And so to what extent are these two approaches kind of potentially leading to a fragmentation of the WTO rules in general and more in general this set of bilateral agreements?
Thank you very much for the wonderful presentation. I'd like to know whether you have an opinion about what's going on in West Africa about mineral extraction, and whether these kind of agreements that you were analyzing make really any difference about the conditions, probably more anarchic at this moment, in which mineral extraction is taking place. I'm thinking of major gold producers like Ghana and Mali in two very different positions, I guess. But if you can elaborate on that. Thank you.
Can I? Thank you very much for your presentation. Maybe I link up to this question by asking whether you think, because we talk about a lot about China in comparing its approach to the European one and to the US one, but we also have, I think, a lot of other actors that are increasing their importance at the international scene, especially as buyers of critical minerals. And I think especially of the United Arab Emirates, which is emerging as a huge buyer of gold. And so I wonder what you think about this, if you could elaborate a little bit on this. And also linked to this, I am not sure how to frame this question, but there is a lot of mineral extraction that happens informally, illegally, and then there is this, and again, talking about gold, I don't know if there are any figures, but I think that a large amount of gold that is extracted from Mali to Sudan and Ethiopia is extracted in an artisanal way. It's illegal. It's smuggled basically. And so I wonder to what extent, how do you fit this part of the phenomenon around mineral extraction into this broader picture of this kind of treaties? Thank you.
Thank you so much. Fantastic round of questions and comments, actually. And there's no mean question. I think we're here to debate. And so all questions are welcome. And the more stimulating, the better. Right. So I think, so I guess the question sort of, what does this sort of architecture of legal instruments, and here I've emphasized the international legal instruments, but I think there's been fair amount of lawmaking at domestic level as well, including in the EU, right? The Critical Raw Materials Act, which also attracted a fair amount of sort of commentary, including around its ability to meet its stated policy objectives, right? Because that piece of legislation effectively set some benchmarks whereby greater shares of extraction and processing would happen over time in the EU. Sort of how does one make sure that those benchmarks, and they're not targets, that benchmarks are actually met, what systems and processes are in place for that. I think sort of similar set of questions applies also in relation to the international instruments. And in some sense, particularly with regards to those international instruments that are effectively a new breed of instruments. And so there isn't the same familiarity that many of us who have been following these issues over a number of years have with some of the pitfalls, some of the issues that tend to come up. So, for example, the MOUs, the strategic partnerships that the EU is negotiating and concluding with a number of producer countries, how will they then translate into practice? And I think here again, from a research perspective, an interdisciplinary approach in my mind is particularly promising, because just reading what's on paper only tells part of the story, right? So part of it really is about what sort of funding mechanisms are there going to be for supporting some of the ambitious activities that are envisaged in some of these instruments. And the EU has set up what they call the Global Gateway, right? So a system for channeling investments, public investments, but also to a significant extent catalyzing private investment into some of these activities, and sort of concluding the strategic partnership is seen as a step towards accessing those resources, right? So what those resources will amount vis-a-vis what, for example, China is able to put on the table, how those resources will materialize, under what terms, which can be quite complicated, particularly when you're looking at private-public partnerships involving sort of private capital into the picture. Sort of it's quite a different story compared to just sort of more conventional type of public investments. So I think, in a sense, the question is an open question, and we'll have to see. Time will tell, in a sense, depending on how these instruments translate or do not translate, or the extent to which they translate into actual practice, driven by very, very practical aspects here, including funding, including a wider set of relations that also transcend just the critical mineral space. I think sort of in relation to the political meaning, in a sense, of the agreement, I think I certainly sense sort of an aspect of that in terms of also just conveying, because now there's now more talk of friend shoring, right? So friend shoring, so who's the friend? So it's also conveying that sort of political friendship in the face of what are framed as being shared challenges, right? So even if the treaty itself is light in terms of obligations, it creates a sense that we've got a framework for dialogue and for looking at these issues together, which I think can have political relevance, even if the legal, in a sort of enforceability sense, the legal implications are limited. I think in relation to the sustainable development chapters in particular, I would say that the US-Japan agreement, the provisions I mentioned there for illustration, are, I think, particularly loose when it comes to enforceability. If one looks at the practice of EU treaties or US treaties for that matter, there is very often much more enforceable, much more specific language associated with that, even though particularly for the older EU treaties, the dispute settlement arrangements are a bit different, compared to the other provisions of the treaty. But I think these issues again need to, as you're mentioning very rightly, need to be looked at not just in relation to the international instrument, but also what's happening in terms of national measures, domestic measures, and the CBAM is an example of that, sort of ways in which sustainable development related, in that case climate related commitments are then translated into trade policy at the unilateral level. In the EU now, there is significant debate about the EU deforestation regulation, the EUDR, which is again a unilateral trade measure that the EU has taken largely on sustainability grounds, but has raised a number of concerns in producer countries. And so I think it's interesting to follow these dynamics, the ways in which sustainable development aspects are translated into international and national, but with international ramifications, instruments. And also the question about level playing field is super, super important, I think, to understand these aspects of sustainable development. And for a long time, there's been, the position of many developing countries has been that, the environment is important, labor is important, but it shouldn't be used as a lever for protectionism, what they see as protectionist practices. And for me, as a policy researcher, I've grappled with a number of challenges around these issues over time, because labor issues are very important, environmental issues are very important. We do work with many developing countries, and we know that there are sensitivities around some of these aspects. And the sustainable development chapters have been experienced with some concern in a number of these countries for these reasons, right? So saying, actually, is this actually undermining what would have been seen before just as a comparative advantage? So I think really important sort of themes and questions to follow. I think in relation to West Africa, I think it's really, a really difficult context. Gold as a sector is a little bit different from some of the critical minerals, but many of the issues are similar as well, including the role of artisanal miners, for example, in relation to gold, that we're also seeing in some sectors within the critical mineral spheres, particularly cobalt in the DRC, for example. And so there are some parallels there. There's a colleague that works, that's very much his focus in his job, and what he does. He works in Mali with in support of artisanal miners there. He works in the DRC with partner organizations in Mali and the DRC, partly to say, there's now greater concern around the sector, the artisanal segment of the sector. Part of that concern is driven by the large-scale buyers that are concerned that next thing you know, your name will be in the news because your supply chain is connected to forced labor and other problems in the artisanal mining sector. And so there is, sort of initiatives to promote standards, etc., and that connects with the sort of instruments we're discussing here that are more like state to state. But the sort of question that colleagues and partner organizations are exploring is, what are the sustainability concerns that artisanal miners themselves have? And there will be some overlap, but it's also, there would be some very different issues also, right? What their priorities are. And so we're seeing, for example, in the context of the DRC, that many artisanal miners would like to have a higher degree of formalization associated with also having areas that are earmarked to them, right? And so there is now a process underway that is trying to do that, actually earmark certain zones where artisanal miners can mine in sort of in a more formalized way, but also then through that, sort of through compliance with certain ESG provisions. But it's not easy. It's not easy because very often the sort of the perspective of the concerns that are more prominent are the ones from a buyer perspective, right? And the buyer is more concerned about certain issues. But I think unless we also speak with artisanal miners, understand what their concerns are, we're not going to be able to understand why is it that, they very often prefer to be informal, and there needs to be a conducive context for them to feel that actually there's added value there's advantage in being part of that more formalized structure. I also fully agree in relation to the importance of looking at a wider range of actors. And I think the time often is tight. And so we end up just talking about the EU and China and the US and the UK. But really, there's a lot of players and the world is changing. The geopolitics are shifting. The government of India has been very busy, for example, developing policy in this area. The UAE, as you mentioned, has been also very active. I've certainly seen if you follow treaties being signed, bilateral investment protection treaties, for example, and also wider trade agreements. Some of the Gulf states, the UAE has been very busy. And so looking at a wider range of players is certainly very, very important. Yeah.
Thank you so much for your presentation. I wanted to ask you if you could elaborate on the distinction between natural resources and products, and whether there are states in this critical mineral sector raising the argument that natural resources are not products and therefore export restrictions are legal under international law on natural resources, which was the argument raised by Saudi Arabia with respect, and whether you see cartels in the future in this domain. The likelihood of cartels and whether this argument then can be relevant to exclude the applicability of the WTO rules.
We have a question online that is related to the standards, I believe, because it talks about the EU due diligence directive, whether it will impact in creating synergies for sustainable approaches and human rights protection, the trade agreements. That's the question from online. Perhaps last question, does any from students? I'm inviting students. Yes, good, student. Last question, thanks.
My question is related to indigenous peoples and indigenous rights. This is what I do. So like, of course, my niche is there. what I'm interested, you were saying that there is, of course, this interrelationship between the international and the national level. Like recently, I've paid attention to the case of New Caledonia, where like the indigenous peoples are actually using as a leverage the national company law to gain new power within the management of nickel minings. And this is a way not really to tackle the environmental problem, but rather the power relationship problems. Like it's more about the social dimension of it. So I am interested in knowing how the international dimension is tackling this, like this balance, if it is tackling, if you can see any patterns, any trends in combining these social and environmental dimensions together, and whether like this local understanding of power relationships is somehow tackled in this international dimension. Yeah, thank you so much.
Thank you so much for another really wonderful set of questions, and also sort of broadening the discussion, which I think is great. I think the question from Marco is a super interesting one, and one that I would like to look up a little bit more myself. I can think of some panels at the WTO, like the EU-Indonesia case on nickel, where the panel straightforwardly applied GATT provisions, both obligations, sort of non-discrimination related provisions, and exceptions under Article 11, which is the quantitative restrictions. And so I think concretely, I'm yet to see the sort of legal significance when it comes to that type of dispute settlement process. What rather ends up blocking, sort of being the spanner in the wheels is the situation at the moment at the WTO with the appellate body. So you have a situation where sort of in that particular case, Indonesia lost the case, or the panel issued a report that found non-compliance with particularly Article 11 of the GATT, but essentially you can appeal into the void. And at the moment things are stalled. But in terms of legal argumentation, I'm sort of be interested in sort of exploring that more, but sort of seeing how that then translates or doesn't translate into concrete dispute settlement outcomes. In relation to the European Corporate Sustainability Due Diligence Directive, certainly there is, the expectations are high at this stage. It's part of a set of measures, unilateral measures that the EU has taken in order to enhance its sort of sustainability ambition, but also as part of a wider set of measures that have also raised sort of concerns among some of the producer countries in terms of the costs of compliance. And I was mentioning earlier the EUDR, the European Deforestation Regulation, that has come up quite a lot in relation to that. So I guess we'll see in particular the articulation between this type of domestic provisions and sort of domestic legislation, and then the international instruments and how that interaction and interface operates in practice. In relation to indigenous people's rights, I think is a really important set of issues, and I briefly alluded to that, I suppose, in the slides, but so much more to say, including about various interfaces, and you're mentioning sort of the social and environmental, the national and international. And so I think these are all really important aspects. I think we are seeing, at least in the sort of best practice in quotes, we are seeing a greater convergence between the social and the environmental. For example, one of the I mentioned the jurisprudence of the Inter-American Court of Human Rights in relation to indigenous peoples, and that really highlights that connection between the social and the environmental. And among the requirements, I think it was even in the slide I put up, among the requirements that the court held states must comply with in order to adhere to respect the rights of indigenous peoples, there is the issue of impact assessment, rigorous social and environmental impact assessments of proposed projects. And so you can see that the connections between the social and the environmental are not only evident in real life, because when you're talking about sort of indigenous peoples, very often there is that very strong connection with the nature, with the environment, the surrounding environment, etc. But also in some of the legal instruments, those connections are drawn. How it plays out in practice very often is a different story, right? And there are very often significant power relations, at play, both in specific places and also at the national level and the wider political economy of it. But it's certainly a theme that I think in this sort of drive to integrate sustainability concerns or sustainable development concerns more explicitly into economic treaties, it's an aspect that I think has suffered from a little bit of neglect. There are many reasons for that. I suspect one of those reasons is the fact that some of the so-called producer countries themselves are very often not that keen on that framing. In fact, governments that say there are no indigenous peoples in our territory. In fact, everybody's indigenous in our country. And so it's also there are themes that also involve certain political sensitivities that make them a little bit more difficult to deal with in this sort of negotiations. But at the moment, as I tried to flag, there are the dots haven't been fully joined when it comes to looking at human rights law, in particular the provisions on indigenous people's rights and this sort of agreements generally on economic treaties, and also specifically with regards to critical minerals.
Questions from students, unless there's a last question from students? No? So let's thank again Lorenzo for his very rich, intense and interesting lecture for today. So I thank last round of applause. Thank you very much.